Hi, everybody. This is Jeff Faller, President of the Apartment Owners Association. And today we're talking about maximum allowable rent increases from August 1st, 2026 to for the whole year and through to the next August, or I guess through the next July. And before we get into that, thank you so much for being a part of AOA. Maybe this is the first time you're watching and you're watching from AOAUSA.com. We do have a YouTube channel, and you can see this after the fact there. And there's a whole lot of other content that we have. Last week, we talked about free gas saving control for multifamily water heaters, and it's literally completely free. So you'll want to watch that video and see how to cash in on that and lower your costs, which would be awesome, right? And we talked about handling problem tenants in LA last week as well. And just a few minutes ago, we finished talking about smart tax strategies for rental property owners. And anyway, so there's lots of content. If you're brand new, there's a member orientation video that you can see maximizing your AOA membership. And so we want to welcome all of you, and especially excited about the Long Beach AOA $1 million trade show that's coming up. Going to be at the Long Beach Convention Center, and that will be a blast. And we're going to have at least about 150 vendors that'll be there, along with multiple speakers, including our speaker today, who is definitely a crowd favorite at the show. He writes the legal Q&A for the AOA magazine. He has his own YouTube channel, but more importantly, he is the founder of Dennis P. Block and Associates. They have around 25 different attorneys working for them, and they do tons of evictions. So he has all kinds of experience, and he's so willing to help and serve all of us and share this information. So we're going to get started here. It's not legal advice. This is general information, in different areas of California. But remember, there are local rent control laws that may not work with the state rent control. But anyway, we're going to just hand it over to Dennis. And at the end, we will have a time where people in the Zoom meeting can unmute themselves and ask questions, but we'll call on you, raise your hand, and anyway, we'll cover that when we get there. But all right, Dennis.
Well, thank you, Jeff. Always appreciate doing this, and it is kind of an invaluable service that you guys put on for the members and anybody actually listening to this, because God knows that navigating the confusing rent increase laws in California is a major task. There is so much confusion on when rents can be raised, how much you can raise them. And my first piece of advice is if you have the legal ability to raise your rent pursuant to a rent control statute, you must take advantage of that at every opportunity. Residential income property owners are the only industry which is subject to price controls. And as I've always said, and actually I got this line from your dad, Jeff, that rent control is nothing more than tenant welfare, and it certainly is true. So we're going
Absolutely.
to go over the issues of how to raise the rents, what forms you can use, how you serve those, and what time periods are involved, and most importantly, how much can I raise the rent based on what jurisdiction your property is subject to. So with regard to raising rents, you have to give the tenant a certain amount of lead time before you raise the rent. If you're going to raise rent 10% or less, it is a 30-day notice of rent increase, a 30-day notice to change the terms. If you're going to raise the rent in excess of 10%, then it's going to be a 90-day notice. That's assuming you have the legal right to do so. But again, if you're raising rent 10% or less, a 30-day notice. More than 10%, then it's a 90-day notice. Now, how do you serve a rent increase notice? Well, that's pretty simple. You hand it to the tenant. That's option one. Option two, you mail it to the tenant. Okay. Do you have to send it by certified mail? No, you don't need to do so. But if you You can do a proof of mailing or you can mail it by regular mail. However, if you do mail it, then you have to allow an additional 5 days for mailing. So a 30-day notice is really a 35-day notice. If it's a 90-day notice, then it's a 95-day notice. So if we're at the 28th of the month and we're going to serve a notice that is 10% or less, and let's pretend it's the 28th of June, you can't have this effective as of August 1st because if you add on another 5 days, it's going to be beyond that. So if you are serving notices, make sure you serve them by the 24th of the month. That would be your deadline, so that they will take effect in 35 days at the beginning of the next month. Okay? Okay, you can always send it by what they call a proof of mailing if you want to have some proof that you did mail it. Now, the next thing is, what do you do in terms of the rent increase notice? What kind of a rent increase notice do you serve? And that I'm going to show you a wonderful notice. Oh, I got the wrong one here. Let's try a different one here. Uh, let's pull it up here. And I thought I had the right one, but okay, now I think I got it. Okay, this is a beautiful rent increase notice that you might know is from the Apartment Owners Association. If you are a member, and I so recommend that you become a member, all you need to do is to fill out this form to raise the rent to the permissible amount. So this form, as you can see here, is a 30-day notice to change the terms of your rental agreement. I've kind of filled it out here. This is where you would put the tenant's name, John Smith. You'd put the apartment number. You put the address right there, the city, and of course the zip code. And you want to make sure that it's effective at least 35 days. So right now we are at June 18th. So I could, if I was serving at less than 10% or 10% or less, I could make it effective as of August 1st, 2026. You can see here that the rent shall be increased from 2,000 to 2,054. This happens to be like a little bit over, a little bit less than a 3% rent increase. And it does tell them here what that rent increase was. Over here, you're going to write the amount, the new rental amount, and then finally the total due. Now, in the city of Los Angeles, you are allowed to raise the security deposit the same rate that you're raising the rent. So I'll get into that, but that would be what this figures here would be. You would check this box and just tell them that you're raising the security deposit from what the original is to that. And again, it's the same percentage as to what the raised of the rent is going to be. Okay. Now that we know what length the notice shall be when you're serving a rent increase notice, either a 30 or a 90-day notice, we now know how to serve that notice on the tenant, either personal service or by mail. But again, by mail, you're going to add in another five-day mailing room. We now know that we can get this wonderful form from the AOA website, and I recommend that you do use this form. But now we're going to actually get into the rents that you are allowed to raise the rent to. What is that percentage? So the first one that I want to talk about is the situation where the rents that you're allowed to charge are unlimited. Oh my God, unlimited rent increases. So right here, and I have it on our shared screen here, if you have, and I don't care where your property is located, I don't care how long the tenants live there, I don't care that the property is held by a corporation or an individual, it makes no difference. In that situation, if you have a single family residence, townhouse, or a condominium, you are allowed to raise the rent to any level. Basically, you're raising it to market level. So whatever the market level is, you are allowed to do so. And you can do it as many times as you like, as long as you're just raising it to market level. If you try to go way above, let's say a price, the market level is $5,000 a month and you raise it to 10,000, that's going to be considered potentially an indirect way that you're attempting to evict your tenant. So that might be considered to be improper. So it is perfectly permissible to raise it to market level. Okay. So again, a single family home, townhouse, or a condominium, it's unlimited. Also, if your property is less than 15 years old, then you again can raise it to unlimited amount. The next one is if the premises are vacant, you just built the premises or you moved out of it, so now it becomes vacant. Again, it's unlimited amount. And next would be if the tenant vacates. If you have a tenant vacate, I don't care what jurisdiction you're in. Again, I don't care who owns it. If your tenant vacates that unit, you are allowed to raise the rent to market level, and nobody can tell you differently. And last but not least, if you are under statewide rent control, and we'll get into that, and it's a duplex, but it's an owner-occupied duplex, you're living there too, and you moved in prior to the time that the tenant moved in, then again, that would, for that existing tenant, you are allowed to raise the rent as much as you like to market level. So that's the issues with regard to unlimited rent increases. We're now going to move on to statewide rent control. So what is statewide rent control? Well, if your property is not subject to a local rent control ordinance like Santa Monica or Los Angeles or Culver City, then potentially your property is subject to statewide rent control. And statewide rent control would be more than one unit. Okay, more than one unit. Of course, townhouses, single-family residences, and condominiums are not subject at all, but you would be subject to their eviction requirements that you would need good cause to evict unless you have a phrase in your rental agreement that this property is exempt from statewide rent control. But if you are subject to statewide rent control, then there is a formula. So we're going to share our screen again. Okay, and there's the screen. The formula for raising rents under statewide rent control is based on 5% per year plus the CPI, 5% plus the CPI, but in no year can it exceed 10%. So let's take a look at Los Angeles County, which is the first column here. The CPI as of August 1st will be 3.7% as of August 1st. And that's computed based on what the CPI is for the month of April of each year. And then it is allowed to be asked for as of August. So this year, as of April of 2026 for LA and Orange County, the rate was 3.7%. So as of August 1st, which means if you were going to do it, you could do it right now because with that 35 days, if you're going to mail it, as of August 1st, you'd be entitled to 5% plus the current CPI for August, which is 3.7%. So the total is 8.7%. For San Bernardino, Riverside, Ontario, the rate CPI is 3.1%. Therefore, the total that you can ask for is 8.1%. That is the same for San Diego, 8.1%, because again, the CPI as it shows here is 3.1%. To our friends up north in Alameda, Marin County, Contra, Costa, San Francisco, and San Mateo, the CPI is 3.8%. So therefore, you're entitled to an 8.8% for all properties subject to statewide rent control. Again, if your property is subject to a local rent control, don't even think about this. The local rent control would occur. But if your property is subject to statewide rent control and you're in the northern area, it is 3.8%. If you're not in any of these areas for the state of California, then you're going to go on the CPI for 3.6%, which means that it would be 8.6%. That would be, for example, if you had property in Bakersfield, which is not in their county, then it's just on the generic one. So that would be 8.6%. So that's what the rent increases are for under state statewide rent control. Okay. Now, let's turn our attention to local rent control. And since right now I believe that most of the people who are listening to this broadcast are in Southern California, let's pull up the next one, which happens to be our friends and yours, Los Angeles City. So they just changed their rules to make it even worse. Unbelievable. And that is under their new rules, how it's computed is 90% of the CPI. 90% of the CPI. No, don't add no 5% to that. It's just 90% of the CPI. So currently, the CPI is 3%. So 90% of that would be 2.7%. So right now, and this is going to include all rent increases, believe it or not, through June of 2027. I kid you not, through June of 2027, based on this formula, 90% of the CPI, which was determined as of February 2nd of 2026, where the CPI was at that time 3%. So you're only entitled to 2.7% for rent increases, and that extends through June 30th of 2026. Again, if you have property that's subject to RSO, the rent stabilization ordinance, that is those multiple unit properties that were built prior to October 1st, 1978, then you're only entitled to a 2.7% rent increase. How the City Council of Los Angeles came up with that figure is criminal, quite frankly, with our insurance, property insurance that's going through the roof, our utilities, and everything else that's going through the roofs, maintenance costs, labor costs, and yet they're giving us a whopping 2.7%. And then I might add for the City of Los Angeles, what they did was they took away your right to, if you supply the utilities, normally you would be entitled to an additional 1% if you supplied all of the electricity for the building or all of the natural gas for the building. And right now they've taken that away. They've also taken away that you were able to, if an additional person joined the tenancy for RSO, the Rent Stabilization Ordinance, you were entitled to an additional 10%, an additional 10% for an extra person moving in. Of course, you could always attempt to do an eviction based on a violation of the contract, but if you wanted to in the past, you could raise the rent an additional 10%. Well, right now, what they've done is if the extra person moving in is a dependent, you are stuck without any rent increases. If it's not a dependent of your tenant, then of course you can raise it 10%. Let's move on. And now we're going to take another jurisdiction, which is unincorporated areas of LA County. This is really kind of a head scratcher with regard to that. So let's move over to that one. So there could be nothing more insidious than the rent increases allowed by unincorporated areas of LA County. To explain what that means is, for example, if your property is in Burbank, in in the city of Los Angeles, in Glendale, in Redondo Beach, in Manhattan Beach, those are incorporated cities. However, there are about 2 million units in LA County where there is not a city. It's unincorporated area of LA County. A lot of that's in East LA. There's parts of Whittier, etc. Or Altadena, for example. Most people think Altadena is a city. Altadena is not a city. It's an unincorporated area. So if you have property in these areas, number one, you're going to have to register the unit with the County of Los Angeles. But in addition, you're limited to rent increases. For standard rent increases, you're entitled to only a 1.93%. If you have 10 or fewer units in LA County, you're considered to be a small property owner and you're entitled to a whopping 2.93%. You do have to register with the county for your unincorporated properties, 2.93%. You have to register them that you're a small property owner, that you own 10 or fewer units in LA County. And last but not least, if you have a luxury unit, which I don't think anybody has, but if you do, you're entitled to 3.93%. That is where the unit has two bedrooms or less, is located within a single structure that has at least 25 units in the building. And as of September 11th, 2018, the landlord received at least $4,000 per month in rent for that unit. Basically, it's almost impossible, but assuming you're lucky enough to have something that they declared to be a luxury unit, then it would be 3.93%. Again, you have to register that with rent control. Uh, Let me get rid of this. If you're talking about city of West Hollywood, where I happen to have a bunch of property, that rate right now is a whopping 2.25%. I mean, this is such an insidious joke that these municipalities are playing upon mom and pop onlys with only one purpose. And of course, that one purpose is to force all mom and pop owners out of business. For the city of West Hollywood, that 2.25% is going to be effective through August 31st, 2026. If you're lucky enough to own property in the city of Santa Monica, it is a 2.3% for the maximum allowable rent. However, they put a ceiling on that of $60 if the current maximum allowable rent is over 25.87, and of course that's effective through August 31st of 2026. Again, you don't have to know all of this, but you got to know where your property is located and what jurisdiction your property is subject to. So if you're in, for example, some Redondo Beach that doesn't have local rent control, well, then you're going to know that it's subject to statewide rent control, depending on what type of a unit it is and depending on how old it is. So you just got to come into understanding the realization of where is my property. And this is especially true for people buying property. We see it all the time. People buy rental units and they have no clue about the rent control statute for their property. They think they can move into their unit. Maybe they can, maybe they can't. They think they can easily ask the tenants to move and raise the rent to market value. There's just no clue. They might have done expensive or extensive re- uh, extensive research with regard to the condition of the building and the whether the roof is good and how is the water and HVAC situations, but they have no clue about the most insidious thing that's going to affect the value of their property based on these rent control statutes. And don't kid yourself, because every city in the state of California, every city has rent control, because if it's not a local rent control, then it's a statewide rent control unless you are exempt from that. So check the city's website, call our office, call the AOL, and give you our best interpretation as to what you need to know. Obviously, it's best to check with the city or the municipality in question and be sure to follow those registration rules. Many jurisdictions like Santa Monica and unincorporated areas of LA County and the city of Los Angeles, if you don't register that unit, then you have no right to raise rent. And if you bring forth an unlawful detainer action, what's going to happen is you're going to lose. Okay. So serve those rent increases. If you have the right to do so, do so. You don't know what the communists or socialists are going to do to landlords in the future. So make sure your rents are at least at market value any way, any shape of the form that you can do so, even using the strategy of a voluntary vacate agreement where you're going to pay a tenant thousands of dollars to get them off your property so that you can raise the rent to market value. Now, if you do raise the rent and the tenant just ignores it, don't accept a partial payment. Okay, send that rent back, or if they sell it to you or put it into your bank account, send them your personal check back and tell them that I do not accept a partial payment of rent. A lot of jurisdictions like Los Angeles and unincorporated areas of LA County have what they call a threshold that you can't serve a 3-day notice if you're above the threshold. So if you accept a partial payment, you're never going to be able to serve a 3-day notice on $50 for this tenant to go forward with an eviction. Okay? So on that basis, never accept a partial payment. Please use, if you are serving a 3-day notice, please use the one from the Apartment Owners Association. They have put a lot of thought process into this and kind of steering you to fill it out correctly. And of course, you can always call my office for assistance. And of course, we can always file actions for you. Basically, I'll be honest, in the city of Los Angeles and unincorporated areas of LA County, it's almost impossible for a landlord to properly serve a 3-day notice. You have to upload it to the city. There's certain forms that have to go with it. There's certain forms that need to be um, posted on your property. And quite frankly, if you don't have those forms, you're just not going to be able to proceed with that. So, at this point, I want to tell you that this kind of exudes the topic of the day, which is navigating the confusing rent increases laws in the state of California. And I'm sure we're going to have a bunch of questions on this. So, Jeff, if you'd like to open it up, I am prepared at this point.
Awesome. All right. So everybody that's in the Zoom, if you could raise your hand down at the bottom, you have to hover over your screen, go down the bottom, hit the raise your hand, and then we will take your question live. And if we don't have anything, we can start in the chat. All right. The first thing that I see here from Patricia is if you post rent increase notices on the tenant's door, is the 30 days in advance acceptable?
Well, technically, it's not supposed to be posted on the door. You're supposed to either mail it or personally hand it to them.
So if you post it on the door, you go by the mailing, right? You go by the mailing
Yeah,
rules.
so don't waste your time. Well, you can post it as a courtesy, but the code specifically says mail it or hand it.
Okay, there you go. All right. And the next question here, can landlord enforce to make up the difference in security deposit equivalent to 1 month rent while raising the rent?
I think you can. However, in the city of Los Angeles, if your property is under RSO, you're limited to whatever the rent increase is.
All right. And then check, is 90% rule on CPI applicable to 4-unit properties in San Jose, Santa Clara, Sunnyvale area? And that would be a big no. That was talking specifically about LA City and the rent control ordinance that's specific there. For San Jose, I looked it up real quick. It looks like for the 4-unit, you are subject to rent control if it's not, if it's an older property, and it would be it looks like 5%. Santa Clara would fall under just regular statewide rent control, and Sunnyvale, hadn't had a second to look it up. But Beckman, Feller, and Chang is the attorneys that write our legal Q&A up in the Bay Area, and they would be able to tell you about Sunnyvale too. Um, so yeah, so that answered that question there. Any other questions in the chat? I will go to the other one here.
Yeah, if you do want to talk to us, if you're in the Zoom meeting room, again, on the bottom, you're going to see the icon that says raise hand, and we'll call on you directly if you want to. I see there's a bunch of people in the Zoom meeting room.
Yeah. And then on YouTube here, we have Michael. How about a townhouse apartment in a 6-unit rent-controlled building built in the 1950s?
Again, if it's a townhouse, that is, you could sell that one townhouse independently from the other units in the building. Then you're not limited to rent increases based on the Costa-Hawkins Rental Housing Act.
All right, let's see here. I've been told the properties built before 1978 and that are under RSO, maximum allowed is 3%. So people really get confused with that one, don't they, Dennis? Because
Yeah, they
law
had
state,
it. Yeah, they had
go ahead.
originally passed the law, the city council, that it was going to be 90% of the CPI effective July 1st of 2026. Then they amended it and we had to all reserve new notices. they amended it to move it back to February 2nd of 2026. So as of that date, if you didn't do a rent increase effective as of February, from that point forward, February 1st, and that point forward, your rent increases were limited to 90% of the CPI, CPI being 3%, so you're getting a whopping total of 2.7%.
So yes, the max is 3%, but it's based on 90% of whatever the CPI is. So if CPI is 10%, it's just going to max out at 3, right?
Yep.
All right. And then Brooks,
Well,
you're
actually,
on.
no. If the CPI was 10%, the city has an upper limit of 4%, period.
Oh, I thought it was 3%.
But if the CPI is, but I'm just saying, I think you just, maybe you misspoke, but if the CPI happened to be 10%, okay, you would think 90% of 10%, but there's a
Yeah.
ceiling of 4%.
Okay, the ceiling's 4. Yeah, that's kind of what I was after. All right. And then Brooks, does this differ depending on the amount of units? So that's all that's there in the question. I'll let you kind of take it like what triggers just
Well,
statewide rent
if
control,
there's
what's
one
the
unit,
trigger
then it's
for
a
it?
single family home. But if there's more than one, you're going to be subject to either statewide rent control or a local jurisdiction, depending on the age of the building.
Yeah. So they have to if they have a 2 unit, is that under rent control?
2 units would be under rent control.
Yeah, unless they're living in one side, right?
And we're subject to statewide rent control. Because if you
Right,
were, for
right.
example, in the city of Los Angeles, it's a duplex and I live there, it doesn't mean anything. Your tenant in the other side of the duplex is going to be subject to that 2.7% rent increase.
All right, here's one. I own a duplex in LA under RSO. My tenant moved in her partner a few years back, violating her lease. How difficult would it be to prove that her partner lives there and bring on an eviction?
I don't think it's very difficult to prove that somebody's living there. As long as you got two eyes, you can see the person coming and going in the morning and coming home at night. You see them using their key to get in there. I'm sure this person who's living there, the stranger, I'll call them, has a car. And we all know that wherever we are right now, including you, Jeff, your car is parked right outside. My car is parked outside. So wherever you are is where your car is. So if you see this person's car parked overnight, you know that person's there. We don't usually have a problem with regard to proving strangers are living in the unit.
Now, is there for LA RSO specifically, is there a window of time where if you know that they're there, is there a certain period of time if it
Okay,
lapses that you
not in
know?
terms of evicting for an unauthorized person,
Okay,
unless they could claim that you waived it. But if you're going to raise the rent 10%, this person is not a dependent. You have to do it within the first 60 days of when the tenant moved in or your knowledge of when that tenant moved in. Otherwise, use it or lose it.
there we go. All right. And then okay, so another security deposit question. It has never been increased along with the previous rent increases. Can I still have the tenants pay towards the deposit to come current? You answered it, but
Well, for the city of Los Angeles, you could raise it, but just the same percentage that you're raising it, so it would only be a 2.7% rent or security deposit increase.
okay, let me see. Renting. Okay, so if someone's using a different form and there's a line for the tenant to sign it on a change of term notice to raise the rent. Tenant wouldn't have to, if there's a signature there, does a tenant have to sign it or?
That's an excellent question. A tenant does not sign a change of terms of tenancy.
Right.
That's the landlord is just the one who's signing it. If the tenant has to sign it, then you're basically doing an addendum to the rental agreement. So, but for a rent increase notice, no, you don't have the tenant sign it because if that was the case, the tenant would never sign it. You'd never be able to raise the rent. So you're just serving a change of terms of tenancy. And again, the AOA form is excellent.
Yeah, and guys, a membership is $97, not a month, but for the year, and you get access to all the forms, and you get access to the helpline. You get the magazine every month. So splurge a little bit. It's going to be you're just going to be able to
Je-
deduct it from
Jeff,
your.
How come you charge me $120 for my membership?
Oh, you're special.
Oh, thank you. Appreciate that.
All right, confirming Manhattan Beach rent. Actually, I should look. look and see if there's anything here. Yeah, okay. Yeah, so Manhattan Beach rent, I'll do this one real quick. Control building built in I'm sorry, in 1970, 2 units would come under state rent control in
That
Manhattan
is
Beach.
that is correct, and therefore you right now you could raise the rent if you haven't done so in the year to take effect August 1st, 8.7%.
Okay, also if existing tenant moves in a non-sibling into a MB duplex, how hard to evict?
Again, if you can prove that somebody else is living there, then we would be serving a 3-day notice to perform or quit. And then because of that jurisdiction that you're subject to statewide rent control, there's a little known rule that after you serve that 3-day notice to perform or quit, and that additional person doesn't move out, the law requires that we then serve a 3-day notice to quit. So it's 2 notices that need to get served, and then we're able to bring forth an unlawful detainer action.
All right, single family residence in LA City, non-RSO, obviously 1 year lease ends June 30th. Served TPA exemption effective July 4th. July 5th or 6th serving a 35-day notice to increase rent 10% effective August 11th.
But you
Therefore,
can't do that on July 4th because then that wouldn't be 35 days. So make it September, serve it July 4th when you have to serve it after the lease expires. So once the lease expires and it's now a month to month, then you can serve a change of terms of tenancy. If you're going to do it 10%, that's great. But since you're already in July, it can't take effect in August. So it's got to be September 1st, 2026.
yeah, so you can't split a month there and prorate it,
No,
just
no prorations.
yeah,
And
go to the
also it
next
makes
month.
it impossible for the tenants anyway. So.
All right. Okay. Here's another one. If the tenant is in a single family home, doesn't allow entry for repairs, and if I want to serve a 3-day notice, does this notice have to be registered with the city of LA?
Uh, Anytime you're serving any kind of a termination notice that you're terminating the tenancy, that has to be uploaded to the city. But if you're just serving like a notice to enter the dwelling, then the answer is no, that's not served.
All right. Let's see, and we'll go back to YouTube here. Okay, oops, I already served a rent increase notice of 10% for our condo. Tenants are in Tustin. Should I retract that and use the CPI of 3.7 plus 5% for a total of 8.7?
And the answer is if it's a single family home, a townhouse, or a condominium, you have the right to raise the rent to whatever level you like. So there's no withdrawing. If you're happy with 10%, you stick with 10%.
Yeah. All right, and that's Tustin. Tustin is in
Orange County.
yeah, it's orange. So yeah. Okay. Very good. What are the rules of rent increases in Ventura County?
Okay, so Ventura County, to my knowledge, doesn't have their own rent control statute, though I might have to look that one up. But assuming it would be under therefore statewide rent control. And again, that would be 8.7%.
For the if it's like I have here it's 7 points. Oh, okay, yeah. 7.7 was last year and it's 8 point I got 8.6% for all other counties.
Yeah, I'm not sure. I'd have to really look that one up, whether that is subject to their Ventura. You're talking about the city of Ventura, is that correct?
Or Ventura County.
Well, Ventura County, it wouldn't be. Ventura County doesn't have rent control, I can tell you that. But
Right.
individual cities might, and the city of Ventura might have their own rent control.
Yeah. I- Okay.
Actually, I just looked it up according to chat, and it says here the city of Ventura does not have
Right.
local general rent control. Instead, it falls under statewide rent control. Well,
Right.
thank God for AI.
Yeah,
So, assuming that's
and I think
correct,
it's yeah, and I think it's 8.6% there. I think because it's the other California counties that aren't listed that don't have the regional CPI. So I think
yeah.
that's 8.6%, but correct me if I'm wrong, or I know that number, we just got that number this last week. I don't know. But anyway, next one, Ashley. So LA RSO was 3% until August 1st, 2026.
It's going to be 2 points right now. If you're going to raise the rent, it's 2.7%. That became effective as of February 2nd, 2026, and will extend until June 30th of 2027.
Okay. All right. And then next one, do you have a chart for Pasadena?
I'm not exactly sure. I believe Pasadena is 3%. Again, you need to check the website for all these municipalities. There are just so many. Is Pasadena rent control amount? I'll see if I can look it up right now. I'm guessing it's 3%.
Mhm.
Actually, what I'm seeing here, the rent increase for Pasadena is 2.25, which extends through um, September 30th, 2026. 2.25, so says AI.
Got another good question here. For capital improvements like foundation repair, new central heating, etc., that the city of LA approves, are these easy to pass on to RSO tenants?
Yes, you can definitely pass capital improvements. You have to get approval from the city. How it works is that the price of the capital improvements is split 50% by the owner, 50% distributed between all the tenants in the building. It's amortized for the tenants over 5 years.
All right. Can you please review what other documents have to be mailed with the rent increase notice in the city of Los Angeles?
And the answer is none. There's nothing specific that has to go with a rent increase notice, but there are certain notices that do need to be posted on the property.
All right. So would you speak about rent increase rules in Oakland? We have a video that we did for the Bay Area, and it's on YouTube, so you can check that one out. So yeah, this one's more California generally, and the obviously Dennis Block is Southern California, so he's able to answer some of those. All right. We have a 60-day notice to vacate served on the 20th. Can we ask to vacate on 8/20?
Yeah, a notice to vacate, assuming it's a proper notice to be served, but assuming it is, then you don't have to serve that notice as on the first of the month or when rent is due. That can be served anytime in any month period. The tenant would have to vacate. If you serve it on the 20th of one month, he'd have to be out approximately the 20th of the end of that notice period. For that proration, you are entitled to a proration of that rent for that period, but you cannot accept rent past the expiration of your notice to quit. If you do, then you've just compromised your notice.
All right, and this question, what is the rent increase for El Cerrito in Contra Costa County? And looking at the trustee grid that we have, this is in your AOA forms. We have a grid that has the maximum allowable rent increases in there. And it looks like Alameda, Marin, Contra Costa, San Francisco, and San Mateo counties has a maximum allowable increase of 8.8%. And prior to that, it was 6.3%. So I hope that answers your question on that one. Okay, this is good. This is a good, there's a lot of people that hear news of what's going on in city council, but maybe don't hear like what actually gets solved. So this is a good question. Is it still correct that LA city tenant must owe at least 2 times the rent before an eviction notice may be served?
And the answer to that is no. It's only one, the month is the fair market value for 1 month. So for example, for the city of Los Angeles, for a one bedroom, for example, it is currently, because it just got raised to 23.28. For a two bedroom, 29.03. A three bedroom, 36.81. And for a four bedroom, $4,098. By the way, I'm not that smart. I'm looking at a chart right now. Now, what I think the person asking the question is confused about is that if your property is subject to the county that is, it's in an unincorporated area of LA County. They have now changed that to 2 times the fair market value. So it'd be 2 times 22, 23, 28 for a one bedroom and 2 times 2903 for a two bedroom. So they're basically making landlords wait 3 months, maybe 4 months before they can even start an eviction.
Great. All right. Here's a tough one. If a rent increase of 4% was given in March, should it be retracted to 2.7%? It's City of LA under RSO.
And the answer is yes, immediately. So what I would do is give the tenant any extra back and explain to the tenant what the correct rent should be.
And maybe a box of chocolate. Just kidding. But yeah, take care of that one ASAP because you don't want to mess with that. All right, I have a duplex in San Francisco. I have not increased rents for several years. And so San Francisco's falling under, it's statewide rent control. I have not increased rents for several years. Can I add these allowable annual increases that have not been used to the 8.8% that you listed? So
Yeah,
can
the
they
answer to
bank?
that is no, you
Yeah.
can't. It's only if you either use it or lose it. But if you're in the city of San Francisco, and again, I'm not an expert for that area, I would imagine you're subject to the San Francisco rent control laws. So it wouldn't be under statewide rent control. So
Well,
definitely check with the
actually, for
city.
that area, Alameda, Marin, Contra Costa, San Francisco, and San Mateo counties, it's actually statewide rent control. I'm sure they have tenant protections. Like I know
No,
Oakland's different.
I
Oakland
would
has,
think though that, for example, the city of San Francisco has a local rent control statute. And if they do, which I'm almost positive that they do, then statewide rent control doesn't apply.
yeah. What is going on concerning the emergency ordinance in LA County or LA City? So on a vacancy, are we able to raise rents to current rates?
Well, we've a lot of the attorneys have a different point of view.
Yeah.
My position has always been that if you have a vacancy under the Costa-Hawkins Rental Housing Act, that you are allowed to raise the rent to market value. I don't see that as a violation. And as I've said on many broadcasts, including my own show that I do on Saturdays, that statute starts notwithstanding any other law for for a vacancy, you are allowed to raise the rent to market level. So on that, based on Costa-Hawkins, which has not been repealed, even though they did try to repeal it in one of the last elections, I think you are free to raise the rent to market level.
And even for LA County, like last trade show, we really pushed for a letter writing drive, a campaign that we had, and I know a lot of you did that, and they did end it. LA County did end as of I think like last in April, I believe. So that ended. And and so yeah, if there's a state of emergency, you get a couple different, you get people saying different things, and uh,
Well, and the current governor calls it a state of emergency. When a pin drops, if there's high
exactly.
winds, it's a state of emergency. So it's like a never-ending state of emergency, dissuading people from raising rents to market level. And
Right.
if you have the ability to raise rents, you do it, okay? And don't let anybody dissuade you from doing so because we don't know what's coming down the pike, and it's certainly not friendly for landlords.
Right. So the recommendation would be, yeah, you can raise to market rate based on Costa Hawkins and also based on just the fact that there's not a emergency in LA County right now. But I mean, there pretty much is all the time. Pretty much they'll find something like Dennis is talking about here.
Yeah,
And
wind blowing.
what's yeah,
The wind blew. Oh my God, it's a state of emergency.
right. Anything they can find, any reason they can find.
Even with the fires where you had 16,000 homes and businesses that were destroyed back in January of 2025, there's 3 million homes and businesses in the county of Los Angeles, and yet for 16,000 they made all these emergency rules. I mean, all it was a total overreach to sit there and put punishment on the part of anybody who happens to be an income property owner.
Absolutely. And I think I saw did I see an email from you about an update on AB 2042? Was there an update on
Yes,
that?
yes.
What you
That
got?
they're trying that. Oh wait, 2022 or 2024? Which one are you referring to?
2042. That's the one.
2042 deals with the fact that it's passed the state legislature, the assembly, but it's in the Senate right now, the state Senate. And what that tells you is that if you got a judgment with a proper service by default in an unlawful detainer action, that tenant can set aside the judgment on the basis that he claims that he didn't get actual notice of the lawsuit. So, for example, in addition to personally serving a lawsuit, an unlawful detainer on a tenant by putting it in the tenant's hand, there are other methods. You can do what they call substituted service, where you hand it to an adult who's at the property and then mail one, or you get something called an order to post, where the court or allows the service of the summons to be served by just merely posting it on the door based on a declaration by a process server that they've been there numerous times in the tenant's evading service. So now, if this law passes, the any tenant will be able to say, well, yeah, it was served properly, but I didn't get personal notice, so I'm going to set aside the judgment. This is an insane law where it can affect your monetary judgments years later or just when you're ready to get a lockout. With a proper service in accordance with California law, they can set aside the judgment. So we're urging everybody to contact your state legislature. And you can, when you do that online, you'll be able to send them a message online and talk about AB 2042 that you do not want him to sign this piece of legislation.
And if you're a little too busy, you can go to the AOA PAC website. Our normal website is aoausa.com. The PAC website is PAC dot AOAUSA.com. And if you go there, you'll see that there's a campaign. We've already um, written a letter for you, and all the information is there. If you just click through on that, it will get that out for you. And again, that this one is like crazy serious, and there's just it's been because it was deceptive, it got as far as it has gotten, and we are really still trying to raise awareness on that and help the legislators understand what's going on here. I think Calra, who wrote it, they know exactly what they're doing, but everyone else just kind of got hoodwinked on it. And we really do need people to call. And again, that's on the PAC website, pac.aoausa.com, and it'll be, if you're on your computer, it'll be on the right side of your screen. And we do have a campaign for Alameda. Yeah, there's a ban on rubs that they were proposing on Tuesday. And anyway, so we again, there's different things that come up, and on that PAC website, we post those campaigns so that you can join in with us. And we have the largest association in the state. Yeah, we have the largest association in the state, but we need everybody to take action. And just because we're the largest doesn't mean that they're going to listen to us. But when we have active members, then it totally makes a difference. So thanks again. Anything else? Parting thoughts there, Dennis, for us?
Be diligent, learn where your property is located and follow the rules because you'll be way ahead of the game.
All right. Thank you, sir. And I can't wait to see you at the trade show coming up here on August 19th. And you're going to tell us how people can get tricked by tenants, if I remember right.
Yes, the tenant scams, what
Yeah.
to look for. So yeah, come on out and I'll have a booth there. There'll be so many vendors. You'll learn how to operate your building so much more efficiently and also more economically. And there's going to be a bunch of speakers, including me. But again, this is very important. In fact, I just tweeted about a case that I just took in where the rent was, they just moved in May of 2026. The rent per month was $5,800. This tenant paid the first month's rent and the security deposit and then announced that they were never going to pay another payment and they dared the landlord to evict. So We're going to talk about the scams that tenants do, how to spot them, and so that you're not sitting there on the shy side losing 8, 9 months worth of rent.
Awesome. So come on out for it. And yeah, like even just this last week, we had one of the members call in and they said, yeah, I ran that civil and criminal investigative search, and the person, it's Section 8 tenant, but they, they have like this litany of cases on the civil side where they're suing the landlords, and they're like, can I evict, can I not take them as a renter? And the answer would be,
Of course, you do not have to take them.
that's right. And so they were so happy. The money was worth it, and they avoided a nightmare tenant. So all that to say, try that the AOA Civil and Criminal Investigative. It's very different than an instant search. It does take 24-hour turnaround, sometimes a little more, and those are business days. But I think I'll take that over having months to deal with a crazy tenant and lose so much money. So
Take care, Jeff. Take care,
take care,
everybody.
everybody. Bye bye.